We just got what could be the clearest evidence yet that Donald Trump may have committed a crime in his efforts to overturn the 2020 presidential election. A question that's kind of lingered over the entire thing, and it comes from an 18-page opinion by U.S. District Court Judge David Carter, was issued yesterday, in which he sifted through tons of evidence and emails between Trump's associates as part of that case brought by John Eastman, one of the Trump's coup plotters. Judge Carter wrote that some of the emails, quote, show the president knew the specific numbers of voter fraud were wrong, but continue to tout those numbers both in court and to the public. So what does this latest ruling mean, not just for the January 6th committee, which is now going to get that evidence, but in terms of the broader case being built by the Department of Justice? Andrew Weissmann spent years working in the Department of Justice, most recently served as lead prosecutor in Robert Mueller's special counsel investigation, now a professor of practice at the New York University School of Law, and he joins me now. It's great to have you here at the table.
Nice to be
here. What do you think the implications of that Judge Carter ruling are?
I think there's several. One, it's worth noting, which I usually keep forgetting, which is there is a federal judge who has found that the former president of the United States has committed a crime.
Right.
In fact, two crimes.
More likely than not, yes.
Exactly, under a preponderance standard. So that is obviously a lot less than proof beyond a reasonable doubt. But
it's not a random cable news pundit.
Exactly. It is not. It is not us.
Yeah, right.
Chatting about our opinions.
Right.
This is somebody who has looked at the evidence, who's done an incredibly serious job.
Not just looked at the evidence, looked at evidence that no one else has gotten to look at.
Absolutely.
I mean, he's got the emails. He's sitting there going through them.
Absolutely. And by the way, he's doing what Judge Cannon could have been doing, which is he's doing what a judge does, which is he went through all the documents. He didn't need a special master. He rolled up his sleeves and did the job himself. I couldn't resist making that comparison.
Yeah. In my business, we call a special master a guest host. That's when you're not
I
working.
love that.
Yeah,
exactly.
That's when you get it. Yeah.
So the other part is that because he's made this ruling that the attorney-client privilege does not apply because of crime fraud, meaning you can have an attorney-client privilege unless you're using the lawyer to commit fraud,
right?
Whether the lawyer's involved or not, is that these documents are now further proof. They can be used in civil cases, they can be used in criminal cases, and they can be used in two types of criminal cases, federal ones and in Georgia.
Right.
Which is, so because what he's talking about is specific things that were said by Donald Trump that he was told that he shouldn't say. So the third
that were
piece,
false.
Exactly. And the third piece is that in a criminal trial, what you are really trying to do is figure out what did the defendant know? What did the defendant do? So here you have the judge specifically focusing on what did Donald Trump sign and what was he told beforehand, which was not just advice of counsel. This was advice of counsel not to do it. Saying that these are things that we cannot verify. If you go forward with this, we cannot say that this is true.
And there's an interesting connection between that behavior as evidenced in Judge Carter's ruling here, which, again, we're coming from him. This is not just some rando, right? And what appears to have been the case in the Mar-a-Lago document situation, in which we have multiple reports that suggest that the lawyers around him told him, stop doing this, don't do it. You have lawyers saying, I won't attest under penalty of breaching the government that because I don't trust you, Donald Trump. And he appears to have run every stop sign they put up in front of him.
Remember, you're talking to somebody. I dealt with the special counsel investigation where Don McGahn is sort of an exhibit A to a lawyer who said, you know what, I didn't sign up for this. And I'm not going to go to jail for you, and I am not going to lie. And what you're seeing, for instance, with Alex Cannon, who I refer to as the good Cannon, not the Judge Cannon, is that he is sort of the new Don McGahn, saying that I'm not going to go forward with this. And that obviously is a huge witness. We don't know the details of it, but you could be sure that the department does.
In terms of that case, new word today, CNN reporting that Kash Patel, of course, who is sort of a, kind of like a right-wing functionary kind of guy. He was like an errand dude for Devin Nunes and then was over doing Lord knows what in the last days of the administration, that Patel spent several hours throughout the morning of October 13th before a grand jury at the U.S. courthouse in Washington, D.C. It's not clear if Patel answered the grand jury's questions or declined to respond, citing his Fifth Amendment protections in his rights. Now, what's interesting here is this is the Mar-a-Lago document grand jury. What does it mean, you think, that Patel is being called before them?
So, to me, there's no reason to be putting Kash Patel in the grand jury, whether he ended up testifying or, as I think is his right, he could take the Fifth But the fact that he's being put in, to me, signals that the prosecutors definitely have Donald Trump as a target, and that is where they're going.
Why?
Because there's no real reason otherwise to put him in. It's not like they're doing a case on Kash Patel. He's so likely to take the fifth himself.
Right.
And remember, there's evidence about what he said. We know from the redacted search warrant that Kash Patel was the person who, in May and June, had made statements saying that Donald Trump had done this sort of spontaneous, miraculous declassification of documents when things were moved from the Oval Office to the residence. They spontaneously just became
the immaculate
declassified.
declassification.
Exactly. Yes. So you can be sure they're going to ask about that, which is, we want to know, is that a possible defense? We want to make sure we've heard it.
I see.
The other
because that's a plausible. I mean, it's a ludicrous defense, but it's a plausible defense, right? Or at least a possible defense.
It's a possible argument. I don't know that it's technically a legal defense, but you certainly, if you're a prosecutor, you want to anticipate that, and you want to know everything there is. In fact, if it's true, you want to factor that in terms of, at the very least, should you charge a case?
That's a good point.
The other point is that Kash Patel also in May and June talked about that he had access to the classified documents, and he talked about releasing them.
Yes.
That also is kind of, if I were at the department, I'd be all over that to know, tell me more about that, because one of the things that you're interested in is not just that you found the documents, but what happened to them. What happened to the information in them? What happened to the documents? Were they copied? Are they in the hands of somebody who should not have them?
And we still think there may be some outstanding. There are concerns that there are some outstanding, they seem reasonable concerns, given the fact you got a bunch of empty folders hanging around. Andrew Weissmann, always good to have you here. Thank you.
Nice to be here.